What's good? It's Trap Savage TV, man. I came across FBG Butta paperwork. It was sent to me by a credible source, man. And, I'm going to read all 7 pages for y'all and let y'all know what you're inspired over this time, man. And I'm going to let y'all be the judge. We're going to get this right now, man. Ain't going to waste no time. Page number 1, man, 1 to 7. As y'all see in front of y'all. Left hand corner at the top. State of Illinois, County of Cook, in the Circuit Court of Cook County. County Department of Criminal Division, people of the state of Illinois versus Rakeem Wilton. Case number 15CR 893202. That's the case number, y'all. So, y'all look that up. It says cooperation agreement. That means he agreed to cooperate with them people, man. So this is what it is. It said this cooperation agreement hereinafter agreement between the Cook County State Attorney Anita Alvarez through her assistant Cheryl Schroeder and Rakeem Wilton. And what it say? And his attorney Haley Austin is made pursuant to Illinois Supreme Court Rule 402. All right, let's go, y'all. It says general provisions. As y'all see, the paragraph in the middle, general provisions. This agreement is entirely voluntary. That means that it's voluntary, means that they're not making him cooperate. He's doing this on his own. And represents the entire agreement between the Cook County State's Attorney Office hereinafter and Wilton regarding Wilton's criminal liability in the above captioned case. Wilton obligations as condition of this agreement. So they gave him conditions for this agreement. This agreement concerns Wilton's criminal liability only, and nothing herein shall limit or any way waive or release any administrative or judicial civil claim, demand, or clause of action whatsoever. Moreover, this agreement is limited to the Cook County State's Attorney Office and cannot bind any other federal, states, or local prosecuting, administrative, or regulatory authorities except as expressive set forth in his agreement. Wilton acknowledges that he has been charged under case number 15CR 893202 with the following offenses: first degree murder in violation of chapter 720-5/9-1 A-3. Then the second, and then his second charge, attempt to first degree murder violation of 720/848-4 72059/1 aggravated battery slash discharge firearm in violation of 720 ILCS 5-12-3.05. And the last one is aggravated discharge firearm in violation of 720 ILCS 5/24-1.2A2. So this is a corporation agreement between FBG Butta and them people, man. So this is here to let y'all know. Now, stay tuned. We're finna go to page 2. All right, man. Now, we on page number 2 now. We finna start. Get your drinks, get your weed, man. We finna hear what's going on, what happened. You know what I'm saying? With Butta. See what happened, see what the crime was, and see what the stipulations was, and the events circulating around him cooperating. So let's go. It's page number 2, as y'all see in front of y'all. 2 or 7. At the top of the page, left hand corner. Wilton understands that the first degree murder, as it is charged under case number 25CR-8932, has a sentencing range of 20 years to 60 years in the Illinois Department of Corrections. Wilton understands that attempt first degree murder, as it is charged under case number 15CR-8932, is a Class X offense. That means that offense is in a whole different category of its own, because that's bodily harm to the highest degree, man. So that's what that's letting y'all know what a Class X offense is. It says is a Class X offense that has a sentencing range of 6 to 30 years in the Illinois Department of Corrections. Wilson also understands that aggravated battery/discharge firearm, as it is charged under case number 15CR-8932, is a Class X offense that has a sentencing range of 6 years to 30 years in Illinois Department of Corrections. Wooden also understands that aggravated discharge of a firearm is a Class 1 felony that has a sentencing range of 4 to 15 years in the Illinois Department of Corrections. Wilton further understands that the sentencing on the murder attempt, first degree murder, and armed robbery shall run consecutive. Wilton also understands that he is charged with possessing a firearm in the first degree murder attempt, first degree murder, and armed robbery, which is proven would be an additional 15 years in the Illinois Department of Corrections on each charge. Wilton has read all of the aforementioned charges against him, and those charges have been fully explained to him by his attorney. Wilton fully understands the nature and elements of the crimes in which he has been charged. Wilton also understands the sentencing ranges described above, and that the sentencing on his pending cases has been fully explained to him by his attorney. Wilton acknowledges that his interview with detectives on May 6, 2015, y'all, May 6, 2015, was recorded, and agrees that the tape is an accurate account of what he told the detectives on May 5th, 2016 and May 6, 2016. Wilton acknowledges that he has seen the tape of his interview in its entirety with his attorneys, and that the tape is a fair and accurate copy of the actual interviews he participated in from May 5th, 2015 through May 6, 2015. Wilton agrees, acknowledges that Wilton's interview was not the result of threats, promises, physical coercion, deceit, or misrepresentation on the part of the Calumet City Police Department or the South Suburban Major Crime Task Force, jail guards, or any other police agencies, representatives of the Cook County State's Attorney Office, or any other persons. So that what they saying right there is that they didn't bribe him, they didn't promise him nothing. You know, he fully cooperated on his own. He came to them and said that he wanted to talk. This is what they saying. Now at the bottom, plea of guilty and sentencing conditions. In exchange for the full cooperation as it relates to this section and this agreement is defined in paragraph 16. Info. Wilton will enter a voluntary plea of guilty because he is in fact guilty to one amended count of conspiracy to commit first degree murder in violation of 720-5/8-2-1A3 under case number 15CR-8932. All other charges will be dismissed. Now look, that's page number 2. Now we're going to summarize it now. What they're saying now, man, is that they got him in a room. He came to them. They sat him down. They got a video recorder, videotaped his statement. They showed it to him afterwards. He watched it with his attorneys. They signed off on it and said it was an accurate and fair description of the events that happened at that time. And, you know, that pushed forward his plea agreement. So Butta, willingly, you know, cooperated, based on, the evidence they had against him and said that he was guilty. So with that, he said, man, I'm ready to talk. So now let's get ready for page 3, y'all. All right, y'all, we back, man. Now look, we're on page number 3, as y'all see in the bottom, 3 of 7. You feel what I'm saying? Left hand corner at the top, it says, Wilton understands that there is a sufficient factual basis to support Wilton's plea of guilty, and that factual basis is sufficient, meaning it's credible. You know what I'm saying? Meaning it's credible that it can be used. Factual basis is sufficient to establish his guilt beyond a reasonable doubt in case 15CR-8932. So when they say beyond a reasonable doubt, that means that they have clear-cut evidence that without a doubt is you. That's what they mean. So if the police ever get you and they say, man, without a reasonable doubt, man, you guilty, that means they got something on you, evidence, something that's going to book you, something that's going to throw the book at you, man. You know what I'm saying? That's what that means. So they saying they had, beyond a reasonable doubt that Butta was guilty in the crime that he was trying to commit, and that, they had sufficient evidence, credible evidence to, charge him with the first degree murder, armed robbery, at that time. So that's what they saying. So we're going to continue. Wilton understands by pleading guilty, he surrenders certain rights, including the following. If Wilton persisted in a plea of not guilty to the charges against him, he should have the right to a public and speedy trial. The trial could be either a jury trial or a trial by the judge sitting without a jury. Wilton has a right to a jury trial. However, Wilton may waive his right to a jury trial. If the trial were a jury trial, the jury would be composed of 12 laypersons selected at random. Wilton and his attorneys would have a say in who the jurors would be, and by removing prospective jurors for cause where actual bias or other disqualification is shown, or without cause by exercising so-called premonitory challenges, the jury would have to agree. We'll have to, let's see. They have to agree unanimously before it could return to a verdict of either guilty or not guilty. The jury would be instructed that Wilton is presumed innocent, and that it could not convict him unless, after hearing all the evidence, it was persuaded of Wilton's guilt beyond a reasonable doubt, that it was to consider each count of the indictment separately. If the trial is held by the judge without a jury, the judge will find the facts and determine, after hearing all the evidence and considering each count separately, whether or not the judge was persuaded of Wilton's guilty beyond a reasonable doubt. At a trial, whether by a jury or a judge, the state would be required to represent its witnesses and other evidence against Wilton. Wilton would be able to confront those government witnesses, and his attorney would be able to cross-examine them. In turn, Wilton could represent witnesses and other evidence in his own behalf. If the witnesses for Wilton would not appear voluntarily, he could require their attendance through a subpoena power of the court. At a trial, Wilton would have a privilege against self-incrimination, so that he could decline to testify, and no inference of guilt could be drawn from his refusal to testify. If Wilton desired to do so, he could testify in his own behalf. So that's summarizing page number 3. They just letting you know, his rights and what he have, in the judicial process. You know what I'm saying, of the court of law. And he chose the process. He chose to cooperate. You know what I'm saying? They saying that anybody whoever tried to cooperate against him, it would be ineffective because, you know, he already cooperated. You know what I'm saying? So basically, he just seeing it, but he has a right to see the people who was accusing him of doing what he did or was attempting to do what he did. So, man, we're going to move on to page 4, man. I hope y'all enjoying it, man. You know what I'm saying? Go comment, like, subscribe, man. Trap Savage TV, man. You already know, man. I'm in the ears of the trenches. I'm bringing it to y'all live and direct, man. All facts, no lies. Let's go. You know what I'm saying? All right, y'all, man. We back to all my savages, man. You know what I'm saying? I hope y'all, you know what I'm saying, the weed kicking in, you know what I'm saying, y'all drink kicking in. I hope y'all taking it all in. You know what I'm saying? Of what I read y'all so far, man, we're gonna continue to go. We on page number 4 right now, man. We got 3 more pages, you know what I'm saying? And to wrap it up, man. So, let's get ready. Here he is. We're gonna start at the top in the left hand corner in front of y'all, as y'all see. It says Wilton understands that by pleading guilty, he is waiving all rights and set forth in paragraphs through above. Wilton attorney has explained those rights to him and the consequences of his waiver of those rights. Wilton further understands his waiving of all appellate issues that might have been available if he had exercised his right to trial and may only appeal the validity of his plea of guilty or the reasonableness of his sentence. At the time of sentencing, the state shall recommend that Wilton be sentenced to 8 years imprisonment in the Illinois Department of Corrections on an amended count number under case number 15CR-8932, which is charged as an attempt first degree in violation of 720-5/8-4A, 720-59-1A1. The charge of attempt first degree murder will be amended to conspiracy to commit first degree murder with a sentencing range of 6 years in Illinois Department of Corrections to 30 years in Illinois Department of Corrections. Will to understand that the court has sole discretion. Discretion means judgment in determining his ultimate sentence and the conditions of his sentence. The state will ask the court in determining what sentence to oppose to consider the following. As you see down here, it says A. Wilton's additional statement given to ASA Cheryl Schroeder and Detective Gaynor on May 10, 2016 are attached as Exhibit A. Wilton's acknowledgement through the written execution of this agreement, see paragraph 8, supra, and through his under oath acknowledgement during his plea guilty outlined above that his statements to detectives on May 5, 2015 through May 6, 2015 is a true and accurate recording of his interview on those days. Wilton full cooperation in the future prosecutions of all offenders in the homicide of victim Ephraim Holly or Howe and the attempt murder of Jerome Burt for the full definition of cooperation in it and as it relate to this amendment and this section. The risk Wilton has placed upon himself by speaking with ASA Cheryl Schroeder and Detective Tim Gaynor on May 10, 2016, which is attached to this agreement as Exhibit A. The risk Wilton has placed upon himself by full cooperation in the future prosecution of all offenders in the homicide of victim Ephraim Haley and attempt murder of Jerome Burt for the full definition of cooperation in as it relates to this agreement in this section. This state, number 11, this state sentencing recommendation is based upon the factors identified in paragraphs 12A through E above in Wilton's criminal background, which is as follows. All right, y'all. So that's wrapping up page 4 now, man, to get into detail and name the people, man, that was involved. So if anybody know, I don't know, but y'all could check this facts. You know what I'm saying? The victim was Ephraim Haley and the attempted murder of Jerome Burt. So these are two people that, Butta and them was after, man, that day. So, you know, y'all go check the facts, man. You know what I'm saying? Let me know. You know what I'm saying? Because ain't no capping on this channel, man. You know what I'm saying? I don't do none of that, man, at all. So, we're gonna get ready for page 5, man. I hope y'all enjoying it, man. Got y'all blunts up, got y'all drink, man. You know what I'm saying? Or whatever you prefer, man. You know what I'm saying? As long as you feeling good, the vibe is right, man, and you chilling, you relaxing, enjoy, man. So we're gonna be right back with page number 5, man. See y'all soon. All right, y'all, man. We back. You know what I'm saying? We back now. We're on page number 5, 5 and 7. We got 2 more pages after this. We're gonna get right into it. Y'all can see at the top up there, at the top, way at the top, it's a little cut off, but you know what I'm saying? I'm gonna try to make it out and see what that is. Let y'all know. But it says a conviction for the Class A aggravated 00W under case number 218620 in violation of 720 ILCS slash CS 5 slash 24 1.6 on August 12, 2013, where Wilton was sentenced to 1 year in Illinois Department of Corrections. Okay, so they say he went to jail in August 12, 2013. He was sentenced to a year. All right, we're going to continue. It says the parties have agreed that the sentence imposed by the court shall be the aforementioned term or the imprisonment in a penal institution, followed by the required mandatory supervised release parole. Other than the agreed terms of the incarceration, the parties have agreed that the court remains free to impose the sentence it deems appropriate. If the court accepts and imposes the agreed term of incarceration set forth, Wilton may not withdraw his plea. If, however, the court refuses to impose the agreed term of incarceration set forth herein, thereby rejecting the agreement, and otherwise refusing to accept Wilton's plea of guilty, this agreement shall become null and void, and neither party will be bound hereto. As a condition of the sentence imposed upon Wilton, Wilton agrees to cooperate fully with the Cook County State's Attorney Office. As used in this agreement, cooperation requires Wilton. Now we're going to look down where it says A, B, C, and D. So this is the requirements for his cooperation. So A, to testify truthfully and provide information against Jeff McGraw, Roshinda Young, Brittany Dupree, and Monique Lane, that Calhoun, and any other responsible for the murder of Ephraim Haley and the attempted murder of Jerome Burt. Such truthful testimony shall be substantially in compliance with Wilton's interview on May 5, 2016 to May 6, 2016. B, to respond truthfully and completely to and any all questions or inquiries that may be put to Wilton, whether in interviews or at any trials or other proceedings. C, to attend all meetings, grand jury sessions, trial, and other proceedings at which Wilton's presence is requested by the state or compelled by subpoena or court order. D, to produce voluntary any and all documents, record, or other tangible evidence relating to the matters about which the Cook County State Attorney Office requires the decision whether as or how to use any information and or slash corporation that Wilton provides, if used at all, is in the exclusive discretion of the Cook County State Attorney's Office. It says at all times Wilton must at all times give complete, truthful, and accurate information testimony. Wilton must not commit any crimes while cooperating with with the state. If Wilton commits any crimes or if any Wilton statements or testimony. So this is letting you know his stipulations of his agreement So this is a continuation from page 4, letting y'all know that what's required of him. You know what I'm saying? And they letting y'all know his co-defendants. So if y'all know them, his co-defendants is Jeff McGraw, Roshinda Young, Brittany Dupree, and Monique Lane Calhoun. So those are the people that he supposedly, you know what I'm saying, told on. So we're gonna keep going. You know what I'm saying? We're gonna continue to page 6 in a minute. But with that said, man, you know what I'm saying? Stay tuned. All right, y'all, we back, man. This is a continuation from page 5. Now we on page 6. As you see at the top from last page where it cut off, it says testimony to prove to be false, misleading, or materially incomplete, or Woolton otherwise violates this agreement in any way, the state will no longer be bound by its representation to Woolton concerning dismiss of criminal prosecution or the sentencing recommendation as set forth above. Woolton thereafter shall be subject to prosecution for any state criminal violation of which the state has knowledge, including but not limited to perjury or obstruction of justice, because Woolton's disclosures pursuant to this agreement constitute a waiver of Woolton's Fifth Amendment privilege against uh, compulsory self-incrimination. Any such prosecution may be premised on statements and slash or information provided by Woolton. Moreover, Woolton's failure to testify truthfully, the refusal to testify, the recognition of Woolton's prior statements, the recognition of other future testimony, or the failure to appear to testify when so requested by the Cook County State's Attorney Office in the criminal prosecutions against Jeff McGraw, Roshinda Young, Brittany Dupree, Monique Lane Calhoun, and any others responsible for the homicide of Efren Hale and the attempted murder of Jerome Burt, or the failure to follow any other term of this agreement by Woolton will, at the sole election of the Cook County State's Attorney Office, cause the obligation of the Cook County State's Attorney Office, as stated in this agreement, to become null and void. The plea and sentence shall become vacated, and all original charges will be automatically reinstated. Further, it is expressly agreed that if the obligations of the Cook County State Attorney's Office within this agreement become null and void due to any failure or actions by Woolton in conflict with this agreement, Woolton understands and accepts that A. Woolton shall waive any claim of double jeopardy. B. Woolton shall waive any statute of limitations claim. C. Woolton shall waive any speedy trial claim. D. Woolton shall submit to the jurisdiction of this court for purpose of the reinstating of his original charges. E. Woolton execution of this agreement constitutes his failure uh, constitutes his failure constitutes his future agreement to the waivers identified in paragraphs 18A through D. Super. Woolton understands that this compliance with each part of this agreement extends throughout and beyond the period of his sentence, and failure to abide by any term of the agreement is a violation of the agreement and is a material breach of the agreement. Wilton is Wilton and Wilton and his attorneys acknowledge that no threats, promises, or representations have been made, nor agreements reached other than those set forth in his agreement to cause Wilton to plead guilty. Wilton understands and agrees that in the event of his conviction is vacated. So that's the end of number 6, man. And we're gonna continue to number 7. It's almost done. You know what I'm saying? I appreciate y'all for rocking with me, for tapping in. You know what I'm saying? The words little, but you already know, man. You know what I'm saying? Intelligence over emotions, man. So you already know I'm tapping into it to give it to y'all clear and direct, man. So, get ready for the last stretch. You know what I'm saying? I see y'all soon with page number 7. All right, man. It's Trap Savage TV, man. We back, man. We on the last page number 7. It's a continuation of page number 6. We're in the home stretch, man. To just see in front of y'all, man. Ooh, boy, that boy Butta, man. DJU, man. What Reese said, you had a lot of goofy dudes on this couch. Better add Butta to the list. Another one, man. So whoever, man, Butta, you went out bad, boy. Went out bad, man. Damn, Butta. I don't know what to say. But like, shit, only the real survive, man. You know what I'm saying? But, only the snitches be set free. You know what I'm saying? The realest survive, but the snitches be set free. You can survive in jail, but the snitches out here free, man. Walking around. Got followers and everything. Man. And look how the generation changed over time. Now look, see? Following the wrong people. Can't get in tune with the wrong people, man. Everybody want to be a chief. There's not enough Indians, man. Everybody want to be a chief, but nobody want to be Indian, man. Everybody want to lead the pack. Guess what? Like they standing on business, like they the ones that's out there really standing up with the morals and the principles, man. But it ain't them though. But perception, y'all. But look, this the last page. We finna get into it, man. Page number 7 at the top, man. It says subsequent prosecution will not be barred by the provisions of 720 ILCS 5/3-4. It says number 22. Wilton acknowledges that he has read this agreement and carefully reviewed each provision with his attorneys. Wilton further acknowledges that he understands and voluntarily accepts each and every term and condition of the agreement. Wilton acknowledges that he is satisfied with the legal representation provided by his attorneys in understanding and execution of this agreement and the legal representation on his pending cases. This agreement is not contingent in any way upon the outcome of any investigation, proceeding, or subsequent trial. And as y'all see right there, agreed to this date, 8/19/2016. Cheryl Schroeder, Assistant State Attorney. Uh, R. Haley Austin, Attorney for Rakeem Wilton. Now y'all look these up. These real people now, man. There you go. In the right hand side, Rakeem Wilton with FBG Butta signature on there. Come on, y'all. Butta, time is up, man. Butta, got some explaining to do. Go on DJU TV and explain this paperwork. ASAP. You want to explain everything else about how King Von was implicated and how King Von was there and how, he tried to pay you and you was the last surviving witness and all that. And then, you know what I'm saying? Try to paint yourself like a victim. Now, guess what? Look what you did here, partner. Feel what I'm saying? Now, anybody in Iraq who's seeing this, man, I don't want to hear nothing. I don't want to hear no, all this. No, 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 man. We don't want to hear that this real, man. I don't even play like that. Go look through my whole catalog of channel. I don't got nothing bogus on my channel. Never did, never will, man. Don't play that. But, man, I appreciate y'all for rocking with me. Salute to all the bloggers, Truth Teller, Trenches News, King AK-47, man. Salute to everybody, that's doing their thing. 16 shot on visuals, man. You know what I'm saying? Everybody that's coming up in the game, that's really rocking out right now and that's, what I'm saying, on their wave. And, salute to DJ UTV, man. You know what I'm saying? He been rocking out with the interviews and stuff like that, man. I ain't never hating bone in my body, man. I'm gonna keep showing love with I'm gonna keep showing love and show respect when respect is due, man. At all times. You know what I'm saying? But with that said, comment, like, subscribe, man. Run these numbers up. It's love.